The subject business law has been divided into three parts. In the first part, the first three topics, you learned about the Australian legal system and some fundamental legal concepts. In the second part, which is made up of parts 4, 5, 6, 7 and 8, you learned about the basic rules regulating the causing of harm, the making and enforcement of deals, dealing with consumers and competitors, and the protection of IP. And in the final part of the subject, topics 9, 10, 11 and 12, you learned about the laws associated with starting, managing, financing and closing a business. So with the assessment, we now have to see whether or not you've actually learned anything in this subject. So 10% of the assessment was based on your tutorial preparation and participation, and as long as you have prepared for, attended and participated in tutorials every week, you could quite possibly have 10 out of 10 here. 30% was for the mid-semester test, and the final 60% will be based on your performance on the final exam. Note that as long as you get a total of 50% or more overall, you will have passed the subject, even if you didn't pass any particular item of assessment. So the final exam will be held on Tuesday, 9 December at 11:30 AM. It will be a 2-hour exam with 10 minutes perusal. The final exam is open book, which means you can take into the exam any written materials. That includes the textbook, which can be annotated or underlined or tagged or even have notes written all the way through it. You can take in your handwritten notes, your printouts of the lecture slides. You can take in practice answers to past exam questions or tutorial questions and so on. The final exam will consist of 6 questions, 6 problem-style questions. All 6 questions have to be answered, so there's no internal choice. And each question is worth 10 marks. 6 times 10 equals 60. We've already assessed topics 1, 2 and 3, so the final exam will focus on topics 4 to 12, but you certainly shouldn't completely ignore the first 3 topics, and topic 3 in particular will be very useful because that's the topic where you learned how to answer a legal problem. So in preparing for the exam, you're certainly encouraged to go over your textbook lecture notes and answers to tutorial questions, but do not limit yourself to just reading material. The best way to prepare for this exam is to practice doing what you will be doing on the exam itself, and that is answering legal style problems. So you should use practice questions from the textbook or from other textbooks or from online or the tutorial questions themselves in order to practice answering that style of legal problem. You will have 20 minutes per question on the final exam, so you should try and give yourself 20 minutes per problem in your preparation for the exam. Outlines of the tutorial problems are already available on the subject website, so you can download those to see how we suggest you actually structure an answer to a legal problem. On the day of the exam, double check the exam timetable, make sure you have the time correct and you have the room correct, and please try and be there at least 15 minutes before the exam is supposed to commence. Don't forget to take along your materials, so your student ID card, your textbook and any other written materials, and pens and other writing implements. In actually writing the exam questions, please make your answers as clear as you possibly can. Use headings and subheadings in order to structure your answer as clearly as possible. Please write legibly. We are entitled to refuse to mark an exam if it is illegible handwriting. If you know that you have a problem with your handwriting, if you know that it can be difficult to read, write bigger than you usually do and space out your writing a bit more. You are entitled to use as many answer booklets as you like. Timing is very important, 20 minutes per question. Keep your eye on the clock. And when answering a legal problem, please use the suggested format: issue, law, application, conclusion. This is the approach that we've been emphasizing and encouraging you to use throughout the semester in the tutorials. Please use this structure on the exam for each of the 6 questions. So let's work through some possible answers to a past exam question. So here's the question. One day you're shopping for furniture for your new home and you find a particular red leather antique armchair amongst the many chairs in Pearl's antique store. You start negotiating with the salesperson, Ahmed. Ahmed has been instructed by Pearl to sell the armchair for at least $3,500. Nevertheless, after 30 minutes of bartering, you manage to persuade Ahmed to sell the chair for you for only $2,500. Later that day, Ahmed tells Pearl that he's managed to sell that fragile old armchair. Pearl is delighted until Ahmed tells her the price you paid for the armchair. Pearl is very annoyed that Ahmed sold the armchair for less than the amount Pearl had insisted upon. Ahmed explains that he thought he would never be able to sell the chair for $3,500 and that $2,500 was the best price he would ever get. Pearl shouts at Ahmed, telling him that the armchair has a market value of $4,000. She tells Ahmed that he is dismissed immediately due to his disobedience. Without Ahmed, Pearl's antique store no longer makes a profit, and 1 year after Ahmed is sacked, Pearl is declared bankrupt. Would Pearl's trustee in bankruptcy be entitled to recover the armchair from you because the sale is a voidable transaction? Here is one possible answer. Pearl's trustee cannot recover the armchair from you because you have paid for the armchair, and that means you have a contract with Pearl because you have provided consideration, and it would not be fair to make you give the armchair back. This isn't a very good answer. It's far too brief for a start, but even worse, it's actually focused upon the completely wrong area of law. It seemed to be trying to answer the question using contract law, when in fact the relevant area of law is bankruptcy law. We would give this answer 1 out of 10. Here's another answer. Pearl's trustee can recover the armchair from you because it is a voidable transaction. Pearl sold the chair to you and then became bankrupt a year later, and Pearl's trustee can recover property that she has sold for less than market value or gave away before she went bankrupt. These are known as voidable transactions. The chair was sold to you for less than market value. This answer is better in that it at least focuses upon the correct area of law, bankruptcy law. It's still not a very good answer. It is not very well structured, it's far too brief, and the reasoning process by which the relevant conclusion was reached is not very clearly made out. In fact, the answer begins with the conclusion, rather than doing what we have encouraged you to do, which is to engage in legal reasoning before you reach the conclusion. We'd give this answer 3 out of 10. Here's a better answer, using the correct structure. Issue: was the sale of the chair to you a voidable transaction? Note that the issue is expressed in the form of a question. Then, set out the relevant law. Voidable transactions are property seized within the previous 6 months under a writ of execution or a garnishee order, property transferred for no consideration or for less than market value to a related entity within the previous 4 years, to a non-related entity within the previous 2 years, or to any entity within the previous 5 years if the transferee is unable to prove that the debtor was solvent at the time. Property transferred with the intention of protecting it from the bankruptcy process and keeping it away from creditors, no time limit, and property transferred at a time when the debtor was insolvent to a creditor in repayment of an outstanding debt, such that the creditor has received an unfair preference within the previous 6 months. So in this answer we've listed the 4 types of voidable transaction. Then under application, we've considered each of those 4 types in turn. The chair was not seized within the previous 6 months under a writ of execution or a garnishee order, so it's not that type of voidable preference. The chair was transferred for less than market value to a non-related entity within the previous 2 years, so it looks like it is the second type of voidable transaction. The chair was not transferred with the intention of protecting it from the bankruptcy process and keeping it away from creditors, and the chair was not transferred at a time when the debtor was insolvent to a creditor in repayment of an outstanding debt. So it is not the third or the fourth type of voidable transaction either. But it is the second type, so our conclusion is the sale of the chair is a voidable transaction. So this is a much better answer. It follows a clear structure, it presents the issue, the law, how the law applies in this situation, and a nice clear conclusion. However, we would only give this answer 5 out of 10. It's certainly not the best possible answer. It does include a lot of information that isn't directly relevant to the problem, and it in fact misses out on a number of important points. Here's an even better answer. Issue: was the sale of the chair to you a voidable transaction? Under law, rather than list every single type of voidable transaction, this answer focuses upon the one that's relevant. It also begins with a nice, clear, simple overview statement about what a voidable transaction is. A voidable transaction is a transaction entered into by the bankrupt person prior to the commencement of their bankruptcy, which may be reversible by the trustee. And then a description of the one relevant type of voidable transaction. Voidable transactions include property transferred for no consideration or for less than market value to a related entity within the previous 4 years, to a non-related entity within the previous 2 years, or to any entity within the previous 5 years if the transferee is unable to prove that the debtor was solvent at the time. There's extra information about what a related entity is. So related entities include business partners, spouses, parents, children, or relatives. And then there is actually information about the relevant defences here. A person may be able to avoid having to transfer money or property to the trustee if they can establish that they had no notice of the bankrupt's insolvency and the transaction was in good faith and in the ordinary course of business. You'll note that under law we've also included references to the relevant statutory provisions, sections 120 of the Bankruptcy Act and section 122 and 123. Under application now, we can actually work through the elements of that particular type of voidable transaction. The share was transferred for less than market value to a non-related entity within the previous 2 years. Therefore, it's a voidable transaction. However, you had no notice of Pearl's insolvency, and the sale of the share was in good faith and in the ordinary course of business. Conclusion: the sale of the share is not a voidable transaction. The trustee cannot recover the share from you. This is, as I said, a much better answer. However, I'd only give it 7 out of 10, mainly because the application section is a little too brief. I think each of those points that are made in the application section can be expanded upon and justified a little more clearly. So here's an even better answer. The first part is actually exactly the same as the other one. The issue is still, was the sale of the share to you a voidable transaction? And under law, we still provide a general overview statement, a description of the relevant type of voidable transaction, a brief explanation of related entities, and then an outline of the potentially relevant defense. So this is the same. Under application, however, there is a lot more detail. The sale of the share took place 1 year before Maria was declared bankrupt. The market value was $4,000 and the sale price was only $2,500. You're not a related party because you're not Pearl's business partner or a member of her family. The sale was therefore a transfer for less than market value to a non-related entity. It took place within the previous 2 years and therefore appears to be a voidable transaction. However, you had no notice of Pearl's insolvency because there was no evidence at the time of the sale that Pearl was insolvent. The sale of the share was in good faith because you were acting honestly, and the sale was in the ordinary course of business because you purchased the share during business hours from Pearl's business place. Therefore, you can rely upon the defense in Bankruptcy Act sections 122 and 123. Conclusion: the sale of the share is not a voidable transaction. The trustee cannot recover the share from you. This answer would be given 10 out of 10. So, in preparing for the exam, please make the time to practice answering law problems under exam conditions, so giving yourself 20 minutes per problem. And if you have any questions about the final exam, the tutorial problems, past exam papers, the subject generally, then please post your questions to the online discussion board rather than email the coordinator or the tutor directly. Good luck.